We're going to wait a few more moments to make sure everyone is in the room. All right, it is now 9:01. It looks to me like everyone has joined us from the waiting room, so I'm going to go ahead and get started. Good morning. I'm Hearing Officer Nicole Kinsey with the Administrative Hearings Office of the State Water Resources Control Board. It is April 21st, 2022. It is at least where I am raining today, so that's something to put on the record. This is a pre-hearing conference in Phase 1B on the applications of North Kern Water Storage District and City of Shafter, Application 31673, City of Bakersfield, Application 31674, Buena Vista Water Storage District, Application 31675, Kern Water Bank Authority, Application 31676, Kern County Water Agency, Application 31677, and Rosedale Rio Bravo Water Storage District, Application 31819, all for permits to appropriate water from the Kern River system. This pre-hearing conference is being held in accordance with the pre-hearing conference order, notice of hearing, and notice of pre-hearing conferences dated February 9th, 2022. This pre-hearing conference is being conducted by Zoom web conference and is also being broadcast live on the AHO YouTube channel. Both the audio and video are being recorded, and we will post files of this recording along with the Zoom generated transcript to the AHO FTP site. The YouTube recording will also be available on the AHO YouTube webpage. If at any time you are experiencing technical difficulties trying to communicate with us, please send an email to the AHO at admin.hrgoffice@waterboards.ca.gov. AHO staff will be monitoring the email inbox throughout our conference today. Assisting me today are several staff of the Administrative Hearings Office. We have Amy Blunk, Skylar Anderson, Kyle Wooldridge, and Nicole Mullins. I also see on the line that we have a court reporter. Good morning, Ms. Colby, and I will just invite you, if at any point I or anyone else moves too quickly or you need a repeat, please don't hesitate to interrupt us and ask for that. So thank you for joining us. I'd like to first move to appearances. To do that, I will identify each of the entities that filed NOIs for Phase 1B of this hearing, and as I do, if you are representing that entity today, please unmute your microphone and state your name. We will start, as our tradition, with the City of Bakersfield.
Yes, good morning, Ms. Kunze. Colin Pierce, Dwayne Morris appearing for applicant City of Bakersfield, and also appearing with me and on the Zoom call is Alexandra Jones, our associate.
Thank you, Mr. Pierce, and good morning, Mr. Jones. City
Ms.
of
Jones,
Shafter.
I'm sorry, it's Ms. Jones.
Ms. Jones, I'm sorry. I apologize. Thank you. City of Shafter.
Morning, Sarah Foley of Best and Krieger for City of Shafter. I'm taking over for Patrick Scahan, who is on paternity leave.
Thank you. Good morning, Ms. Foley. And I did see your notice of intent and your appearance filed with our office. So thank you for that.
Great, thanks.
North Kern Water Storage District.
Good morning, Hearing Officer Kunze. This is Scott Cuney, Law Offices of Young Wooldridge, on behalf of North Kern Water Storage District.
Good morning, Mr. Cooney. Buena Vista Water Storage District.
Good morning, Ms. Kinsey. Ryan Becerra of Barkowitz, Chronic, and Shanahan for Buena Vista Water Storage District. Pairing with me is Isaac St. Lawrence, the district's general counsel.
Thank you. Good morning, Mr. Becerra and Mr. St. Lawrence.
Good morning.
Rosedale Rio Bravo Water Storage District.
Good morning, Jennifer Spalletta Law for Rosedale Rio Bravo.
Thank you. Good morning, Ms. Spalletta. Kern Delta Water District.
Good morning, Ms. Kinsey. Craig Carnes with Ellis and Schneider Harris Donlin for Kern Delta Water District, and Richard Iger, general counsel for the district, is also appearing.
Thank you. Good morning, Mr. Carnes and Mr. Iger.
Good morning.
Kern County Water Agency.
Good morning, Nick Jacobs with Somax Simmons and Dunn, representing the Kern County Water Agency.
Thank you. Good morning, Mr. Jacobs. Tulare Lake Basin Water Storage District. Do we have Mr. Keel on the line, who usually is with us? Not today. All right, I will move on. Kern Water Bank Authority.
Good morning, Ms. Kinsey. Kevin O'Brien of Downey Brand for Kern Water Bank Authority.
Thank you. Good morning, Mr. O'Brien. Do I have Mr. Keats on behalf of the public interest groups? And do I have anyone from the California Department of Fish and Wildlife? All right, is there anyone else on the call today who intends to participate who has not already identified themselves? All right, I'll go ahead and move forward. First, I'll just talk through the filings that I've received just to confirm with you that there aren't any errors or omissions. Then I'll lay out a couple of items that I think are appropriate for us to talk about today. And then, of course, I will always have the fourth item, well, the last item, which is, are there any other procedural issues that we need to get to? But first, I wanted to note that the deadline for parties to file case-in-chief exhibits was April 4th. The AHO did receive exhibits from Buena Vista Water Storage District, Kern County Water Agency, Kern Water Bank Authority, and North Kern Water Storage District. And now that I'm saying that, that may have been in conjunction with the city of Shafter. I don't know if I missed that. You can clarify that for me. Is there any other party who submitted case-in-chief exhibits that I missed? And then, Mr. Cooney, can you clarify, was the North Kern Water Storage District submittals in conjunction with the city of Shafter, or are you working?
Yes, they are.
Okay.
All of those submittals are on behalf of both North Kern and the city of Shafter.
Thank you. And then I just wanted to remind all of you, I'm sure we've been through this before, so you know, but that all the submitted exhibits are available in the AHO FTP folder for this matter at this time. So as usual, it's a good idea to review the files there to make sure that it reflects what you believe has been submitted. That's what is in those files and publicly available is what the AHO's understanding of the record is. So if there are any errors or omissions, please bring that to our attention as soon as possible. On April 18th, I received evidentiary motions from several parties, the City of Bakersfield, Buena Vista Water Storage District, Kern Water Bank Authority, and Kern County Water Agency. And I realize that some of those parties submitted more than one. I don't think I need to list them all off here, but just recognizing that some of those were multiple submittals. Did any other party submit evidentiary motions with respect to the case-in-chief exhibits that I did not mention, that I may have missed? Good, okay. I received pre-hearing conference statements from Buena Vista, Kern Water Bank Authority, and North Kern and City of Shafter. Did any other party file a pre-hearing conference statement that I may have missed? All right, and finally, I did want to note that on April 20th, I received a notice of errata from Buena Vista. So noted that we have that in our files, and also the updated NOI from City of Shafter to add Ms. Foley as an attorney for the party and to our service list. So we received those as well. Are there any other filings that I didn't mention that you think is appropriate to bring to my attention that I may not be aware of?
Ms. Kinsey, Ryan Becerra for Buena Vista.
Yes.
But one note, we did note in reviewing the public FTP site that our statement of incorporation of materials from the state board's public files was not there. We circulated a copy of that by email. So all parties should have it at this point.
Okay, and have you looked lately? Is it still not there?
I need to do that.
Okay, we will also take a look. So thank you for bringing that to my attention. I believe I've seen the document, but I don't know. I may have accessed it in a different way. So we will check that.
It struck me that it would perhaps looked a little different than many things, and so it might not have been moved over to the public site.
Yeah, thank you. I'll move on now to what I think is our agenda for the day, the issues that some of you identified in the pre-hearing conference statements, which I appreciate. First of all, I had a few thoughts that I wanted to share about Mr. Becerra, about Buena Vista's evidentiary motions regarding the scope of the hearing. I don't want to get into the merits, but I thought it would be appropriate for us to briefly talk about that. So I thought we'd move to that first. The second issue is the order of proceeding. It looks to me like the parties may have come to an agreement on that, which is wonderful. I appreciate that, but we'll talk through that just to confirm. The third issue, there seems to be some question about whether the witnesses should be presented individually for purposes of cross-examination or by panels. So that will be our third issue to address today. And then I don't have any more on my list, so then I'll open it up to any other procedural issues that we might have that you think would be appropriate. Are there any comments or concerns about proceeding in that order as we go forward today? So we'll start with Buena Vista's evidentiary motions. I've had a chance to briefly review the motions. I've had a couple other things on my plate in the last couple of days. So this is by no means but anything near a final consideration. I just had a couple of thoughts after reviewing the motions, and I thought it might be helpful to me, if you think it would be helpful, Mr. Becerra, that it may be that your client, you would want to file something additional on the deadline. I think it's April 25th for responses to the evidentiary motions. This wouldn't be a response, it's sort of like a supplemental. But when I read your motion, it struck me, I mean, you raised a few issues about the scope of this phase 1B proceeding and limitations on the degree to which we should be examining Buena Vista's water rights in the scope of this hearing. And you raised points that you've raised before, which are helpful. The 2010 decision by the State Water Board, the State Water Board's regulations concerning fully appropriated streams petitions. You, I think, pointed to some board precedent, which I certainly plan to take an additional look at. But when I read the arguments, what comes to mind to me right away, and maybe just from my background and where I'm coming from, is a collateral estoppel claim. It sounds like claim preclusion, and it has some draw to me to look at it in that framework in part. I mean, recognizing that there are these other arguments, but to look at your argument in part as a collateral estoppel argument, because then I have a nice framework of elements that I should be looking for, right? So it has an appeal to me. I certainly, what the point that comes out most prominently is whether or not these issues about the scope of Buena Vista's water rights were actually litigated in a prior proceeding. I assume that would be decision 1196. There may also be, I mean, maybe it's claim preclusion too, because as I understand it, Buena Vista was a party to that proceeding. I don't know. But I thought I just wanted to alert you that that's where I was going to some extent in the thinking, recognizing that there are these other arguments based on the regulations that would be independent from, possibly from a collateral estoppel argument. But I wanted to give you the opportunity, since I was thinking about it and those arguments weren't explicitly in your motions, the opportunity to clarify some of those issues and invite you to address those issues if you wanted to and thought it was helpful in a supplemental briefing document. It could be very short. It could say, you know, we think that this has no application and you're totally on the wrong track, hearing officer. I don't know. So I did want to open that up to you, and I will stop now because I don't have additional thoughts. Again, I read the motion once, I went through it. This is just where I was going, but I thought it might be helpful to raise what I was thinking so we can get to the best outcome here and put all the arguments on the table if possible. Do you have any comments on that, Mr. Becerra, or thoughts?
First, thank you, Ms. Kinsey. I appreciate your consideration of it. I think we may ask for a supplemental opportunity to brief the matter after today's discussion. One thing that has occurred to me is that you addressed a pretty contentious issue in phase 1A via pre-hearing motions. We haven't had that procedure here. We effectively attempted to do so in our evidentiary motions, in particular the motion that's based on decision 1196. I guess I think about it a little differently than claim preclusion or collateral estoppel. I think about it as simply water right priority. The Kern River and the water rights on which the decision 1196 were based have been, let's say, litigated over and over and over since then. Decision 1196 addressed whether Lake Isabella made additional water available for appropriation. In short, the State Water Rights Board found that it did not. So, among other things, Buena Vista's pending application at the time was denied on the grounds that there was no unappropriated water. When the Water Board took up the first fully appropriated stream listing in 1989, the matter was litigated again with a party seeking new rights in the Kern River, asserting that the existing rights were not what they needed to be in order to preclude applications. The Kern River parties submitted substantial evidence again, and the Water Board in decision order 8925 held that there was no unappropriated water in the Kern River. When the Water Board then in 1992 adopted its regulations to govern fully appropriated streams proceedings, it included initially reinterpretation of prior decisions as a potential grounds for reopening fully appropriated stream declarations. The Kern River parties, including Buena Vista, again commented to the Water Board it was not appropriate. The Water Board had determined the rights in the stream and that the stream was fully appropriated in 1964 and asked them to please not revisit that. Everyone had invested based on that decision. Buena Vista in particular submitted an August 26, 1992 comment letter that said, please do not include reinterpretation of rights. That would just encourage people to rehash the issues endlessly. The Water Board heard that comment and deleted that portion from the regulations. We then, of course, had the 2009 hearing, which was based on the changed circumstances of the Kern Delta forfeiture and flows through the intertie. And the Water Board found that those two changed circumstances justified modifying fully appropriate stream declaration. That is the appropriate scope of this hearing. What results from the 2010 orders based on the Kern Delta forfeiture and the flows through the intertie? Buena Vista, we have known for a while, was going to be subjected to some sort of attack by the Kern Water Bank Authority to attempt to reduce the second point right to make more water available. We still don't know exactly what that attack is. It appears based on the consistent citation of December 19th, 1914.
Well, let me stop you right there, Mr. Becerra, and I appreciate what you're saying. I know it's in your motions, and
yes.
And I understand that, and I certainly, I'm like, as I said, I have made an initial reading. I'm going back to them. I'm looking at this. I also want to clarify that I know you've cabined these as evidentiary motions, and to some extent, that's not exactly what they are. I mean, they're also evidentiary motions, but there's this other element of what is the proper scope of this hearing, just generally. I expect that you're a fine attorney. You will make these arguments in your opening brief. You'll make these arguments in your closing brief if the scope of the hearing is not limited through the evidentiary motions, which I haven't yet ruled on. And I think that's an appropriate place to make those arguments and to do those things. So I just want to keep us on track for today because I have these in front of them. But I will open up the opportunity, if you would like, on behalf of your client, to file additional briefing on this issue of collateral estoppel or res judicata, if you think it would be helpful to me. And I just wanted to flag for you that I think it might be helpful to me to say, yes, this is an applicable doctrine here that you might think about these issues in this framework, or no, we just don't think that framework is appropriate in this context, and you're on the wrong track here. I will turn to you, Mr. O'Brien, because I expect that you have something you may want to say in response. So I will give you that chance.
I'm going to not respond to Mr. Becerra's arguments on the merits. I think this isn't the day to do that. I don't have a problem with additional briefing, but certainly would want the opportunity to respond. We are preparing a response to the original objections and will be prepared to file those Monday by noon. It seems to me that if we're going to open this up to further briefing from Mr. Becerra, perhaps it would be most efficient to extend the deadline for Kern Water Bank Authority to respond, so we can respond to everything submitted by Mr. Becerra at one time and in one response brief. I think that would make for a more clear exchange of briefing on these issues, which are important and complex. So if we are going to allow Mr. Becerra a supplemental briefing, which I have no objection to, I would request that Kern Water Bank Authority be given, say, an additional week to respond to the full suite of evidentiary arguments that Buena Vista is making, and then you'll be prepared to make your rulings.
Thank you, Mr. O'Brien. I appreciate that. This is where I'm going to go now because we are up against a May 2nd start of this proceeding, and I believe Kern Water Bank will be presenting its evidence first, which will be in potentially, depending on the ruling here.
Ms.
Some of
Kinsey,
yes, Mr. Becerra, do you have something to add?
Yes. We filed 3 evidentiary motions. One is on what I'll call the scope issue. That concerns decision 1196. The second concerns specific factors related to Kern Water Bank Authority concerning judicial estoppel and equitable servitudes binding their land. The third is a motion asserting a variety of evidentiary objections. The second 2 seem to me any responses should be due well by the 25th. If we're going to proceed with a May 2nd start date, we need to know what evidence is coming in. On the scope issue, I need to think about whether we actually need any additional briefing. We took our shot at doing that in the one evidentiary motion. What I would suggest to you, if you believe you need additional time to consider this issue, which is complex, is that we potentially break up the dates of the phase 1B hearing, and potentially we could start with what is clearly something of a dispute on what I'll call the global issue of unappropriated water. North Kern has submitted a technical analysis. Kern County Water Agency's evidence focuses on that. The Water Bank has presented Ms. Boissevain's testimony, which deals with that issue to some degree. You could start the hearing with that presentation and then determine how much you want to hear in this debate between Buena Vista and the Water Bank, either later in the week of May 2nd or potentially on May 9th and 10th. We have dates reserved for rebuttal as well. It seems to me that you may have the ability to proceed efficiently with this hearing in that manner. As I said, I need to think about whether we really need any further evidentiary briefing or not. We might, but we're happy with the motion we filed. We believe the history recited there is the pertinent history.
And just for the record, Ms. Kinsey, we would object to any bifurcation of the 1B hearing at this point. We've prepared our witnesses. I think all the parties have. If Mr. Becerra needs time for additional briefing, I can commit to getting response briefing done more quickly so that we don't have a delay in the hearing. I don't think that's in anybody's interest. So I think the key question is to Mr. Becerra, does he want to file a supplemental brief? If the answer is yes, then I would ask for at least a few more days to respond to that portion of his evidentiary objections. I agree with Mr. Becerra that the others we can probably go ahead and respond to on Monday.
All right, that's helpful. Thank you. I'm not going to delay the start of the hearing, and at this point, I don't think it makes sense for me to attempt to, or all of us to attempt to try to break up the pieces of it. Although I see there are some issues that maybe could be addressed in a different order. But I think at this point, I'm not inclined to do that. You've indicated, Mr. O'Brien, that on this issue that you'd like a responsive briefing. My initial thought here was no. I just told you what if I'd kept my mouth shut, we would be on schedule. But I'm trying to really just flesh out the issues in a way that's helpful to me. But if you are if this is something you want, and you want the opportunity, Mr. O'Brien, to respond to whatever Mr. Becerra may have to say, which it sounds like he hasn't decided. I'm not going to put you on the spot, Mr. Becerra, to commit one way or the other. You're invited to file a supplemental brief. You don't have to, or it could be very concise, as I indicated. But Mr. O'Brien, what would be your request for a date, given that supplemental briefing for Mr. Becerra would be due April 25th, and we start the hearing the following Monday. And I fully intend to get out an evidentiary ruling on all of these issues before Monday so that we know what we're doing. So I'm going to get something out on Friday. What would you like?
Not seeing Mr. Becerra's supplemental brief, it's a little difficult to say, but I think we could commit to turning this around in 48 hours.
Okay. So, I mean, with the caveat that there's always a possibility that you may file something with me. Mr. Becerra files a 100-page motion, which I'm not encouraging you to do by any means.
Will not be receiving one of those.
Yeah, okay. So, and then Mr. O'Brien says, what is this? This is all new. And then maybe we have to have a conversation. Let's put a deadline. If you are going to file if Mr. Becerra files an additional briefing and you are going to file a response, I'd expect to see that by the end of the day on April 27th, so that I have an opportunity to read it and get out whatever my rulings are by the 28th, 29th, so that we know what's happening on Monday. Now, I will say to all of you, I know this is a tight schedule. I know some of these motions involve significant amounts of evidence. I will try to if there are portions of the ruling that I can get out sooner, I will do that so that all of you are on notice. I appreciate your efforts here. I think the evidentiary motions, although they're extensive, they're not ridiculous. And I appreciate that you narrowed down your focus onto what is concerning to you. And I will do my best to carry my part and I'll let you know as soon as possible what is going to happen during the hearing the next week and what evidence will be in. Now, I know we're about to talk about order of proceeding, but on this issue, is there anything else that we need to talk about?
I have one request, perhaps just for efficiency. I can certainly tuck this argument into our brief that's due on the 25th, if I could have a little more than 20 pages. I currently have 20 pages and probably 3 more is adequate, if that would be acceptable. Or if you would prefer a separate document, we can prepare a separate document.
Additional 3 pages is fine. It's probably most efficient just to tuck it in there if you have anything, if it turns out you have anything to say. So
thank you.
That request is granted. And Mr. O'Brien, I'll look to you to if you respond, that you would have similar discretion in the amount of pages that you use.
Yes, thank you.
Thank you. Anything else before we move on? All right, let's talk about the order of proceeding. I appreciate all of you bringing this up because that will, I'm sure, be helpful to you. I think we had either we had agreed or I had ruled that Kern Water Bank Authority would be first to present the case in chief. Sounds like Buena Vista would like to be second, and there's no objection to that. So that makes sense to me. Kern Water Bank, then Buena Vista. I understand the suggestion and agreement from the parties is that we would then move to Kern County Water Agency and wrap up with North Kern and City of Shafter. That sounds fine to me, and I think that order makes sense, but are there any objections or concerns with proceeding in that order in presentations of cases in chief? Great. Thank you. Thank you for working that out. The third item I have is this question about whether witnesses will be presented for purposes of cross-examination in panels or individually. I understand, Mr. O'Brien, the Kern Water Bank Authority would like to present its witnesses as panels. I understand Buena Vista objects to this approach.
Ms. Kinsey, if I might.
Sure. Yes.
After thinking of, our primary concern has been logistics. Thinking about it a little further, we're okay with everyone presenting witnesses and panels. If that's what you'd like to do.
So you're withdrawing your objection to the, essentially, to the presentation and panels. I will then turn to the other parties. Do you have any comments about the best way to present witnesses in this proceeding? Mr. Jacobs, please.
Ms. Kinsey, I think it's really up to what works best for you. I don't understand the efficiency of the panels. I think it's more efficient to have a witness and then have people cross-examine he or she, and then they get to go home, as opposed to everybody hangs out until all the testimony is over and then there's a panel. But no, no firm conviction.
Yep. Thank you. I'm experimenting still. So this is my thought on the panels, and maybe you can help me through this. I'm looking at especially Kern Water Bank's witnesses, and some of the testimony there is a lot of testimony, which is great. We're going to get into detail of some issues. It does bring to mind for me, it may be better for me, I don't know if it's more efficient or not, but just better for my understanding if we proceed individually, especially where those witnesses have lengthy and detailed testimony that I assume we may be stepping through in cross-examination in a fair amount of detail, that it may make sense to go one by one. And also for the, as you noted, Mr. Jacobs, for the efficiency for the witness, that if there are 3 witnesses on the panel and they each are going to take quite a bit of time to go through their testimony and then be cross-examined, that may not be the best way to proceed. So I do think the panels work better when we have witnesses who are generally testifying about the same thing and their testimony is relatively short. It kind of makes sense to group them together and then we move through it. But I don't see as much of that in this phase 1B when I looked through the witness testimony. So I don't know, I'll turn to you, Mr. O'Brien, whether you have any supplemental thoughts about how we proceed or strong opinions or anything you'd like to add.
I would not put this in the category of a strong opinion, Ms. Kinsey. I think in particular, our first 2 witnesses, Dr. Miltenberger and Dr. Jeff Davids, there's a certain interrelationship in the testimony. Some of Dr. David's testimony builds on the historical facts that are addressed in Dr. Miltenberger's testimony, and there are cross-references in Dr. David's written testimony to some of Dr. Miltenberger's testimony. So I simply thought that to the extent that parties, for example, want to ask Dr. Davids about a specific historical fact, that having Dr. Miltenberger there to provide whatever information might be relevant would be most efficient. But if from your standpoint it's better to take the witnesses one by one, I don't have a strong objection.
Okay, thank you.
Hearing Officer Kunze, with regard to the presentation by North Kern and the City of Shafter, first of all, I defer to what is best for you, and as maybe the hearing progresses, you can call an audible if that's appropriate. But in regard to our 2 witnesses, we're not objecting to it being in panel, and if that's helpful to you, we can do it that way. And they are, it's a collaborative engineering report, and so there's maybe some good appropriate logic to doing it that way. And I would let's just wait and see how it goes, and if that's what's helpful to you, then we can do it that way. I have to confess to you, I've not had my own witnesses in a panel and what that means, but I think if it helps you get it done efficiently, we support that.
Well, let's do it this way. So I appreciate this constructive effort here. Let's do it this way. Let's have the default be that the witnesses will be presented individually. I think, and I appreciate, Mr. O'Brien, that there's some interrelationship, and it's actually may benefit those who are cross-examining them to ask questions, that cross over and have both witnesses available. But just because of the length of testimony, let's go with a default that they'll be called individually. If we want to modify that, or if I think it's without interrupting the schedule of any of the witnesses, but if we want to modify that during the hearing, especially as we proceed through the different cases in chief, let's talk about that, as I think we've worked well together in the past and we can work this out in the most efficient way possible. But my initial inclination when I looked at the testimony and the complexity was maybe it makes sense to do these individually. So let's go with the default that they will be presented individually. If we want to modify that, we can. So let's proceed that way. Now with that, are there any other procedural issues that we should address today? Open floor.
I had one, Ms. Kinsey. It looks like Mr. Jacobs intends to call Mr. Moody and Mr. McCarthy, staff engineers, and we have listed them as potential rebuttal witnesses. Their depositions were taken and all the parties had an opportunity to participate. I'm wondering if it wouldn't be most efficient to submit those deposition transcripts so that they're part of the record. I think we will be referring to them. It would give you an opportunity to read them in advance of the hearing, and then to the extent that Mr. Jacobs or anyone else wants to call those gentlemen as live witnesses, he can certainly do so. I just think it would allow us to move things along if those deposition transcripts were in the record.
Mr. Jacobs?
Yeah, so actually you beat me to the unmute button, Mr. O'Brien, but I am not intending to call those witnesses, but I wanted to talk to you today, Ms. Kinsey, and if you would like to hear from them, I'll call them. If you don't, I don't intend to. And I don't object to a stipulation that we submit the transcript from the depositions, but I'm not intending to call them unless you're interested in hearing from them.
And just maybe to briefly add on, I don't feel the need to call them as rebuttal witnesses if the transcripts are in the record. So if the transcripts aren't in the record, I would reserve the right to call them as rebuttal witnesses.
Thank you, Mr. O'Brien. Thank you, Mr. Jacobs. It sounds to me like the way to handle this, I don't think at this point, I don't see a need to call them as witnesses. It sounds like the two of you and maybe the other parties would maybe come to some stipulation about submitting at this point the deposition transcripts. The only reason I see that there may need to be a stipulation is because we're past the April 4th due date. If you can come to an agreement, that's great, and those can be submitted. Maybe we can come to an agreement right now. But if there's any objection, of course, I would want to have for parties to have the opportunity to object, and I could rule on that. Mr. Becerra, I saw you unmuted yourself. Do you have a comment on this?
Yes, thank you, Ms. Kinsey. What I would suggest is that we reserve this matter and people can decide what to do as to rebuttal testimony.
Mm-hmm.
If anyone thinks it's necessary to call them as rebuttal witnesses, that's fine. If anybody wants to submit deposition transcripts in rebuttal, we can talk about it then. It doesn't sound like it's one we need to really deal with at this point.
That sounds appropriate to me.
I don't know that I agree with that, Ms. Kinsey.
Okay.
Just in fairness, you're going to be hearing testimony from the get-go about the water availability analysis process, and I think there's going to be an argument as to which WAA methodology was the appropriate one. And I do think the deposition testimony is relevant to that general discussion. And so you having that at the front end of the hearing in order to be able to review that testimony as you listen to the testimony of Ms. Boisevane, Mr. Young, Mr. Van Camp, and others, I think would be helpful to you. So I would like to get a stipulation to simply move those deposition transcripts into the record. If counsel are not willing to so stipulate, then we'll have to deal with it some other way. But I think for you as a hearing officer, I think it would be most beneficial to have that information before we start the hearing.
And that's fine with me, Mr. O'Brien. If you can get the stipulations and that is brought in, I wouldn't have an independent concern about bringing that in with the case in chief evidence. I'll leave it to you to work with your colleagues as to how to bring that in and whether there are any objections. And if there are objections, we will deal with those. I can deal with them if need be when the hearing starts, and we can talk those through when we'll all be together. So if that seems appropriate, please proceed. It sounds like this is not something we'll settle today, but talk with your colleagues and see if we can come to an agreement. And I don't have any, from my point of view, I think it's fine whether it comes in now or if you agree to some other time, that seems appropriate to me.
Okay, thank you.
Thank you for that. Are there any other procedural issues we should address? Great. Well, I thank you for your participation today. Thank you for your focused pre-hearing conference statements, because I think it helps us move through this. Thank you for your evidentiary motions, and I appreciate in advance your responses that I will receive on the 25th. And I will see all of you, I believe, on May 2nd when we reconvene. So thank you and have a wonderful, hopefully rainy day.
Thank you.
Thank you.
We are adjourned.
Thank you.